Dear students, welcome to this important topic on result management. We will talk about what is result management and what is the process behind the result management as per the WADA code. First, I like to introduce myself. My name is Jai Singh. I am Assistant Project Officer in National Anti-Doping Agency and the head of the Education and TV department. In the result management is one of the key document and key process in the anti-doping program, which outline how a sanction part will be imposed on athlete who violate the anti-doping rule violations. So, we will talk what is WADA, about National Anti-Doping Agency in India, about the World Anti-Doping Code and the international standards. We will also talk about the World Anti-Doping Agency's international standards of result management, the important and the mandatory document. What are the findings we came across in the result management process? The type of suspensions imposed on athletes during result management process. We will also discuss about the process of adverse analytical finding. We also discuss about the result management process of non-analytical cases. We will also talk on the result management process of whereabout failure cases. We will talk what are the anti-doping rule violations, what are the sanctions imposed and to whom the sanctions are imposed. It may be athlete, it may be athlete support personals, or it may be other person also. And what are the chances of get the reduction to athletes, how an athlete can get the reduction of the sanctions. So, first I like to tell about the World Anti-Doping Agency. World Anti-Doping Agency was we called as a WADA, was established in 1999 to promote and coordinate and monitor the fight against doping in sports in all form at the international level. So, it is a global body which regulates the anti-doping program at international level. It is funded by the national government and the International Olympic Committee. So, World Anti-Doping Agency is an international body. So, in India, we have National Anti-Doping Agency, NADA. As NADA, other countries also have their anti-doping agencies which runs the anti-doping program. So, accordingly, similarly, we have National Anti-Doping Agency which promotes, coordinate and monitor the doping control program in sports in all its form in India. NADA adopts and implements all the anti-doping rules and policies which conform with the WADA, cooperate with other anti-doping organizations and promote anti-doping research and educations. So, basically National Anti-Doping Agency adopt and implements all the anti-doping code, the international standards, the guidelines and implements in India in all form at the national level. So, first we will just brief talk about what is World Anti-Doping Code. Code is a very important core document that provides the framework for harmonized anti-doping policies, rules and regulations within sports organization and among the public authorities. So, it is the main important document which provides a harmonized policies all across the globe. So, it cannot be like that. Some policies is different in India and it may be different in other, for example, in Japan. So, the policies, the rule and regulations in the anti-doping program is equal and in a similar way to be adopted at global level. So, in addition to this, to the code, there are 8 international standards, mandatory standards, and which are integral part of the code, even though they are published as a separate document. So, this is the main document, the code, and in addition to this code, we have other 8 mandatory documents also. So, these documents, the code and the document needs to be implemented at the national level by the agencies at the national level. So, we will see what are the standards and what are the guidelines, standards is in place. So, total there are 8 standards, starting from international standard for protection of privacy and personal information, international standard for code compliance by signatories. It is a standards where all signatories have to be compliant with all mandate standards. It is written in the document. Then comes the international standard of educations, where all policies and document it has been given in the document how the program runs, an education program run in the country. Then comes the prohibited list. It is released annually by the World Anti-Doping agencies. So, currently we have 2024 prohibited list in place. So, next year we are going to have 2025 prohibited list in place. This prohibited list revised annually by the World Anti-Doping Agency. It carries all the prohibited, name of all prohibited substances, methods which is applicable in the sports. So, any laboratory have to analyze a sample, they have to check these prohibited substances in the samples collected from the athletes. Then comes the important documents is the therapeutic use, international standards for therapeutic use exemption. What is therapeutic use exemption? If any athletes, for just like a normal person, any athlete can also be get injured, or it may be have injury also. So, in that case, an athlete has to be very careful whether in unknowingly or knowingly he is going to take any prohibited drugs for his treatment. So, in this document, through this document, we have to make sure that if any athlete required any prohibited drug for his treatment, then he or she should have proper TUE certificate, therapeutic use exemption certificate from the anti-doping organization. Then comes testing and investigation, international standard of testing and investigation. This important documents provides the guidelines and the procedures how the dope testing procedures go through and investigations proceed. Next comes the laboratories, international standards for laboratories. How this is an important document for WADA accredited laboratories where the sample was analyzed. How the samples are analyzed, what is the mechanism behind it. So, each WADA accredited laboratory has to be followed this guideline standards, otherwise they will not get this certification from accreditation from WADA. Then comes the important document, result management. This important document, result management, carries the guideline, it covers the guideline, the responsibilities for any anti-doping organization or the result management authority, how they will proceed in the case where athlete was reported positive for anti-doping rule violations or any athlete support personnel or coaches. So, how they will be given sanctioned. So, all the guidelines and the procedures are given in detail in the international standard of results management. So, as we are talking about the result management, So, we will discuss in detail about the result management procedure. As I already told you that international standard of result management is one of the mandatory international standards of WADA. The purpose of international standard of result management is to set out the core responsibilities of anti-doping organizations like NADA, we are in India with respect to result management. How the result have to managed. The Result Management Authority or ADO manage the results of anti-doping rule violations committed by an athlete, athlete support personnels or other person that fall under its jurisdiction. So, it is very important to know that the line is the fall under its jurisdiction. So, it is not like that ki I will impose or manage the results of any other national. Only the anti-doping organization or result management authority can manage the results of the athlete, athlete support person and other person who are there under jurisdictions. For example, suppose in the case of anti-doping agency NADA India, we manage the result of all the Indian athletes who are come under in the jurisdiction of our. So, we will now talk about the findings. What are the type of findings we came across when any report came positive? Once samples collected by an athlete, collected by doping control officers, empaneled doping control officers, the samples being couriered to the WADA accredited laboratory, then the laboratory gives the results of the samples being collected. So, two different type of results we came across. Findings are, what are the findings? First, the negative findings where the sample has no prohibited drug reported. Atypical finding, we will talk about what is the atypical, small traces of prohibited drug reported in the finding. Then comes the adverse analytical kind. There is a clear case of presence of prohibited findings. Samples reported of prohibited substances reported in the sample. Then comes non-anticals. It is not linked with the samples being collected and sample has been reported. It is non-antical. Suppose during the sample collection process, if an athlete evade the sample collection process or he tampered with any part of the doping control. So, these any whereabout failures. So, these type of analytical findings are called non-analytical findings, where direct presence of a prohibited substance is not there. So, other than direct presence of a prohibited substance, it is called a non-analytical findings. So, we will go one by one. First, as I told you, negative findings, if no prohibited substance or methods or evidence of the use of prohibited method is detected in the sample, the laboratory, the WADA accredited laboratory will issue a negative test result. So, any finding, preliminary finding reported by the World Anti-Doping Agency within 21 days of sample being deposited at the WADA's laboratory. So, if no presence of a prohibited substance, then reported as a negative finding. Then comes the atypical finding. In certain circumstances, the presence of a prohibited substance in the sample may constitute an atypical finding, a merely small presence, as per the instructions or as per the guidelines provided in the international standards of laboratories or related technical documents. So, in such cases we cannot say it is totally negative or a totally positive, it is just in between both of, we call it as an atypical finding, but it needs to be processed. It may be processed or thoroughly investigated to come to the conclusion final conclusion by the anti-doping organization, whether it may be totally negative or it is being, or it may be adverse analytical finding. So, how we will proceed for these type of atypical findings? First, if the report received, we review the case, whether any applicable therapeutic use exemption has been granted. Is there any TUE has been granted for the finding? Okay. Second, then we came, is there any departure of international standard of testing and investigation or international standard of laboratories that may causes the atypical finding? It is apparent that atypical findings are caused by the ingestion of prohibited substance by a permitted route. So, these are the three important steps we check or review if first we come across any atypical finding. If we are sure, if we are confirmed that does not, if the review does not reveal atypical, does not reveal a TUE or departure or ingestion of a permitted route that causes the atypical finding, further investigation will take place. In such type of atypical finding, we do not notify an athlete. We investigate through our INI investigation wing and decided whether to bring this atypical finding towards an adverse analytical finding. On the conclusion of the investigations, once we are concluded with an investigation, we will advise the athlete as whether or not there is evidence of administration of a prohibited substance or method. If there is no evidence, then no further action will be taken. If there is evidence of administration, we will report the atypical finding as an adverse analytical finding. So, atypical finding will be converted into the adverse analytical finding. Then accordingly, the process of result management will take place as a adverse analytical finding. So, this is the atypical finding. So, now next we will talk about what is adverse analytical. So, as per the code article 2.1, the presence of any prohibited substance in a athlete sample reported are called adverse analytical finding. Of mere presence of a prohibited substance in athlete sample. In the case of non-ethical cases, article 2.2, use or attempted the use by an athlete of a prohibited substance. Code article 2.3, evading, suppose any athlete evade, refused or failing to provide the sample, collection. Then comes the article 2.4, whereabout failure, where any elite level of athlete, what is, you will just check with your not will go through what is whereabout failure. Whereabout has to be provided by a registered testing pool athletes, elite pool of elite athletes in any country or any federation. These elite level of athletes are come in registered testing pool. So, all the athletes who come in the registered testing pools have to provide their whereabout information 3 months in advance, where they will stay, where they will train and where they will compete. And on each day of their whereabout information, they has to be provide a 1 hour slot, 60 minute time slot to anti-doping organization, where they can be tested by them in that 1 hour slot. So, all registered testing pool athletes have to provide, it is mandatory for them to provide the whereabout information in advance, 3 months in advance. So, in that case, if any athlete failed to provide whereabout information or missed the test when any anti-doping organizations come to collect the sample in the provided 1 hour slot. If they miss, then it constitutes a missed test. So, any combination of missed test or filing failure within the 12-month period by an athlete is in a registered testing pool constitute a whereabout failure, which comes in Article 2.4. Then comes the Article 2.5, tampering or attempted to tampering with any part of the doping control process. So, it is also a rule violation. Then comes the Article 2.6, possession of any prohibited drug or method with you, an athlete if any possesses. Then comes the Article 2.7, trafficking or attempted to trafficking any prohibited substance or methods. Then comes 2.8, administration or attempted to administration of an athlete by an athlete of any prohibited substance or method. This also constitutes a rule violation. Then comes Article 2.9, assisting, encouraging, aiding, abetting and conspiracy covering up any other type of intentional complicity and attempted complicity involved an ADRV or any attempted ADRVs. Then comes the Article 2.10, associating in a professional or sports related capacity with a person such as coach, doctor, physio, trainer who served a ban, who have been found guilty of a criminal and disciplinary offence equivalent to a doping violation. Article 2.11, acts that threaten or seek to intimidate another to discourage them from sharing information about doping, also refer as a whistleblower. If somebody provides information to other athlete for other athlete, in such cases, or retaliating against another for doping, doing so. So, this comes the rule violation. So, there are 11 articles where athlete support person or other person can be sanctioned. So, these are 11 anti-doping rule violations. So, Article 2.1 covers the adverse analytical findings, and then from Article 2.2 to 2.11 covers the non-analytical finding part of the result management. Apart from the anti-doping rule violation, there are provisional suspensions are also being imposed on athlete. If any athlete has been reported for prohibited drug, which is specified category. What is specified category? Like steroids, which having long term effect on a body. So, in that cases, and in that heavy drugs, or we can say that specified category of drugs, the sanctions are on a higher side. In that cases, if any report came positive for specified drugs, then mandatory provisional suspension is imposed immediately on athlete. If an athlete comes for positive for non-specified category of drug, then voluntary provisional suspension was imposed, or athlete can also opt themselves a provisional suspension. Then they will get the benefit of sanctions or the benefit when the final verdicts come to them. So, there are type of provisional suspension also imposed till the final hearing concluded for that particular athlete. So, we will discuss now in detail about the result management process of adverse analytical finding cases. If any sample reported positive for prohibited drug. So, first step will receive a report, then will initial review the case about the TUE, any applicable TUE is granted or not, any international departure from international standard of testing and investigation and laboratories, and any drug which is given as a through permitted route. So, initial review will take place first step. If we are sure, we are confirmed that there is no TUE or international departure or any permitted route is given, then a notification was issued to the athlete. Then in the notice we give a chance to an athlete whether he want to test his B sample or not. If or then explanation. We give two options for the athlete. First is the B sample analysis and second about the explanation. So, if athlete wants to have a B sample tested to confirm the report which is came the prohibited drug which came reported in the drug in the body in the sample, if he or she wanted to confirm whether the drug is actually reported in the sample, then he can go in the he can test in the laboratory about the B sample, the second bottle of the samples collected during the sample collection process, which is called as a B sample. Then he can go and analyze the samples. Once if it is confirmed that B samples, the sample, the prohibited substance is also reported in the B sample also, then an explanation also received from athlete, we issue a formal notice of charge to the athlete. Once formal notice of charge is issued to an athlete, then the case is transferred to the hearing panel for the further hearings, legal hearings. The first case goes to the anti-doping disciplinary panel, a lower sort of legal bench. The case is been athlete been called and has given the chance, fair hearing chance to provide the explanation how the sample has been entered in his body. The athlete has been given a fair chance to represent himself or through a legal counselor to present his or her case in the before the anti-doping disciplinary panel. So, first is the disciplinary panel. Once the decision has came from the disciplinary panel, anti-doping disciplinary panel, if and once the case has been it has been sent to the athlete, it may be 2 years, 4 years also. If athlete is not satisfied with the decision of the anti-doping disciplinary panel, he can go to the higher legal bench which is called anti-doping appeal panel, where an athlete can represent his case against the decision of the anti-doping disciplinary panel. If athlete is an international level athlete, athlete can go to the international court, a court of arbitration of sports, CAS in Switzerland. If athlete is a national level athlete, he can report or appeal against the decision in the national bench, which is called as an anti-doping appeal panel. The anti-doping panel or appeal panel is a separate independent bodies which is constituted to hear the these cases or in the these type of cases about the anti-doping rule violations cases. Next, we will see what is the result management process for non-ethical cases. We received in non-ethical cases, we have seen that we have the cases of tampering, refusal, evading, failing to provide sample collection, whereabout failures. So, those are all non-ethical cases. So, we in that such cases we receive no laboratory report, we receive the report from our doping control officer in the supplementary form, where all including all evidences about the cases. We review the cases about all the procedures as per the result panel standards. We review the cases, all the evidences which is enclosed in the cases, and we provide suspensions. It may be mandatory in as case to case as per the articles. Suspension may be mandatory also, voluntary also, and optional also. So, once suspension imposed, notification is issued to the athlete and seeking an explanation about the particular case. Once we receive the explanation, if we are satisfied that is a no, if we are not satisfied with the explanation provided by an athlete, then the notice of charge is issued to concerned athlete. Once after the notification of notice of charge issued to the athlete, the case transferred to the hearing panel for the legal proceeding, as we have talked in the adverse and legal finding cases. Now comes the result management process for whereabout cases. Why I am highlighting this result management process for whereabout cases, because it is very different from other non-identical cases. As we have already see, if any combination as per article 2.4 of WADA code, if any three if any three combination of whereabout mistest or filing failures came across by an athlete in the registered testing pool within 12 months, then the whereabout failure come across. So, in such cases we provide first a letter to the athlete seeking explanation why whereabout failure has came across. If on the basis of explanation provided, if we are not satisfied, then we go through the next step of anti-doping rule violations. If we are satisfied with the explanation provided by an athlete, then case can be dropped out with a notification letter issued with reason to with copy to WADA, International Federation and Anti-Doping Organization. Once, if on the other hand, if we are confirmed and we are not satisfied with the explanation provided by athlete, then we issue a notice to the letter to the athlete stating that we are not satisfied with the explanation provided by you. Then the case is been forwarded to the administrative hearing by the independent person. We give opportunity to athlete whether they will require an administrative hearing, administrative review by independent persons. If athlete agreed to and requested to have administrative review, then he has to request to NADA that yes, I want administrative review of my case before final record of the procedure. Then the administrative review is conducted by the independent persons. Once the administrative review has conducted and it is confirmed, then we record as a whereabout failure. If there is a no administrative, there is no whereabout failure, then it has been recorded and notification has been issued to the athlete, whereabout WADA, International Federation and NADA. Any such record of whereabout failure, if an athlete in 12 months period, then ADRV was constituted. Next, we will talk about the type of anti-doping rule violations. What are the? As we have already talked about the 11 anti-doping rule violations, we will see what are the bans period is imposed against each anti-doping rule violation and which is applicable to whom. For example, Article 2.1, the presence of prohibited substance in athlete and athlete sample, a sanction can be imposed up to 4 years and it is applicable to athlete only. Article 2.2, use or attempted use of by an athlete of a prohibited drug, prohibited substance, the sanction may be up to 4 years ineligibility and it is applicable to athlete. Evading, refusing or failing to submit the sample collection, then the ban is also up to 4 years and it is applicable to athlete only. Article 2.4, where the whereabout failure clause violations are there, then it is the ban period is up to 2 years and it is applicable to athlete only. Tampering, Article 2.5, tampering and attempted tampering with any part of the doping control, the sanction will be up to 4 years and it is applicable to athlete, athlete support personals. Athlete support personnel comprises of coach, manager or any supporting staff. It may be doctor also, physio also and any other person. Article 2.6, possession of any prohibited substance or methods is also leads to up to 4 years of sanctions and it is applicable to athlete and athlete support personnel. Trafficking or attempted trafficking in any prohibited substance or prohibited method is also have up to 4 years to lifetime ineligibility will be imposed and it is applicable to athlete, athlete support personnel and other personnel. Article 2.8, administration or attempted administration of an athlete by to an athlete or any prohibited substance or prohibited method is it is here also a 4 years of ineligibility to a lifetime ineligibility can be imposed to athlete or athlete support personnel. Assisting, Article 2.9, assisting, encouraging, aiding, abiding and conspiring or covering up or any other type of intentional complicity and attempted complicity involving an ADRV or attempted ADRV, 2 years to a lifetime ineligibility can be imposed and it is applicable to athlete, athlete support person and other person. Article 2.10, associated, in associating in a professional or sports related capacity with a person such as coach, doctor, physio, trainer who is serving a ban or who has been found guilty of a criminal or disciplinary offences equivalent to a doping violation, sanction up to 2 years can be imposed and it is applicable to athlete, athlete support person and other persons also. Article 2.11, act that threatens or seek intimidated another to discourage him from sharing information about doping or retaliate against another for doing so. A 2-year to lifetime ineligibility can be imposed and it is applicable to athlete, athlete support person and other person also. So, these are ban periods against each anti-doping violation and whom it is applicable to, and this is a very important part. So, in during hearing process an athlete can also get the reduction from the total period if he voluntarily admitted the anti-doping rule violation in the absence of any evidence. So, there he can get the reduction also. Identifying the athlete use of a non-specified substance was not intentional. If he proves that is not intentional, then he also can get the reduction. Establishing no fault or negligence or a significant fault or negligence, if he proves that, he or she can get the reduction of sanction. Reaching a result management agreement of ADRV reduction in cases of 4 to or more years ban. If he agrees and he admitted the fault and he entered with the result management agreement with ADOs, anti-doping organization, then he get the reduction of 1 years in the cases where 4 years or more eligibility is imposed. Reaching a case resolution agreement with WADA and ADOs. Here a mutual reduction of sanction can be given to an athlete. So, these are the cases where these are scenario where the reduction can be given to a sanctioned athlete. These are the references I have prepared. The document I have referred during the preparation of this. So, you can refer the international standard of ISRM or guidelines also, National Anti-Doping Agency website. You can refer the result management process or other anti-doping organization website also. Thank you.